right, so are you Brandon Lewis Chillo? And is it Chillo or Chalo?
Shallow.
Shallow. Mr. Shallow was previously in court. Well, first on probation in two cases, clause numbers 19-32303, excuse me. Yeah. 19-32403 and 19-32404. Both of those for sexual assault of a child. Those are both 10-year deferred probations. There was a motion to revoke probation filed, and we were previously here. Mr. Shiloh pled true to counts 1 and 2 in both of those motions, which alleged, real quick, all right, so count 1 pled true that he did not successfully complete the sex offender counseling and was terminated from that program. And then count 2, he pled true that he possessed sexually stimulating or oriented material on his phone in violation of the order. I've received an updated pre-sentence report. Has everyone had an opportunity to review that report?
We have, Judge.
Is that dated January 26th, Your Honor?
It is.
Yes, I've received it as well.
Are there any additions or corrections to that updated report?
No,
Your Honor?
no.
All right. And then so attached to that also, part of that report was the letter from Julie Ayala, who is the sex offender counselor. That was dated July 25th of 2025 with the specifics of why he was terminated, I believe, from that counseling and treatment program. You've seen that as well, correct?
I have.
All right, and that there was no agreement for any type of punishment in these cases. And so, Mr. Lewis, you may proceed.
Yes, Judge. Judge, we are asking that Mr. Chalo be allowed to continue supervision with some amendments to the probation. I know one of the things that even probation even recommended or suggested in their report was the cognitive track of ISF. We think that will be be very appropriate in this situation. I have had talks with Mr. Shiloh about the violations as well as basically the situation. And he's been very clear to me as far as him understanding how serious they are. But I think that the cognitive track will be able to enhance or basically really enhance that thought process for him. To not minimize any of these situations or requirements from the sexual offender program or just probation in general. Understand that it is all very important, unless or it wouldn't be a requirement of it. And he's more than willing to comply. The situations that led into these violations here, it was a situation where, given how they happen for situations, the information on his phone or through the polygraph situation, a lot of that dealt with, communication with him and a loved one of his. And he had to understand that even those type of situations, it has a determining factor. It can be a determining factor dealing with his probation. And after, and him realizing, recognizing that, he knows that, hey, there's certain things he just can't do. Like, I'm not saying he thought he could do them, but he knows now just how imperative, following every violation of rule for their sex offender.
So one thing I didn't say, and I'm sorry to interrupt,
okay,
but in addition to those 2 10-year deferreds, the plea agreement on this case was different and kind of a hybrid
right
back when we did this. And there was, in addition to the 2 sexual assault of a child cases, there was also an improper relationship between educator-student case and an online solicitation of a minor. Those 2 cases, he was given 6.5 years in prison. So went and did some amount of time in prison,
right
then got out and on probation.
right.
So I can, and Ms. French, I'll give you an opportunity in just a minute, but it doesn't make any sense to me that 90 days in ISF would do more than a 6.5 year sentence in prison to make it clear to Mr. Shallow how serious it was that he got out and followed the rules on probation. That was all gone over when he was given probation. The fact that he got probation, this was a young person who was in middle school that it's anyway. I just don't think arguing for me to leave him on probation is probably where you need it.
Okay.
It doesn't make it, the browser history, the titles of the things that Mr. Shiloh was looking at all have to do with teen pornography. So clearly the most important thing is that he follows through and with treatment, because he's exactly where he was when we gave him this opportunity back then.
Mhm.
So, Ms. French, your position.
Yes, Your Honor, and just because it's the way I'm used to doing things, I would ask the court to take judicial notice of both of his pre-sentence investigation reports, since I'll be referring to them.
Sure.
Both. One, the date of the report, January 26th, and the first one, May 12th of 2025. And I, just to add to what the court has noted, Mr. Shiloh was placed on probation on May 5th of 2021 in this case. He went 30 months without any notice of a violation that caused an MTRP. But then in January of 25, 7 violations were noted, including a DWI offense. He pled to 5 of those 7 violations: failure to remain in Jefferson County, the new offense, failure to report new arrest, curfew violation, failure to pay court assessed fees. That was not even a full year ago, Your Honor. He signed, as far as I can see, and I would ask for judicial notice of this as well, that in both of the probation orders in these cases, 19-32403 and 404, he signed an understanding as to the conditions of his probation. It is this prosecutor's opinion that it was by grace that he received probation in those cases. And yet, less than a year ago, he pled true to 5 of 7 violations. Now he's pled true to both allegations in the MTRP that was filed.
What was the outcome of, I'm trying to look back and now see, of the motion,
It appears to
or
me
was there a motion?
there was a motion filed January 10th of 25, and there was a hearing where he pled true to those violations
See that,
on March 24th of, I'm sorry,
April 29th.
correct. And then the MTRP was dated January 26th for a date of sentencing of March 3rd. So
So what did I do
it looks as though
in that first motion?
on June 24th of 25, there is an order that he enter and successfully complete JCDI and return to the sex offender caseload upon completion. And I
Yeah,
believe
that.
he was also, and I'll ask Ms. Simon, is that when he was also assigned to go to the sex offender treatment program?
He was assigned at the beginning of his probation.
Yeah, that came from the beginning.
Okay.
Okay, thank you. Now I see this. So this is the second motion
Yes, ma'am.
to adjudicate in these
Correct, Your Honor.
cases. When does anybody, and Ms. Simon, maybe you do, have the date when Mr. Shallow was released from prison?
Back, like originally,
On the 2, so he got 6.5 year sentences on those 2, the online and the solicitation and the improper education student one.
22, September of 22.
September 9th.
So September 9th. Sure.
Okay, so you did roughly a year and a half. Ish.
In prison,
Mm-hmm.
3.5 years. from 19 until September 9th. So it was
No,
pretty-
in actual prison, not in our jail.
prison, yes, I did about a year and a half.
Okay. So you're on parole now still, or are you off?
I complete parole April 27th. Next month.
So you're still on parole?
Yes, ma'am.
Yes, ma'am. Next one.
Okay, got it. I'm sorry, Ms. French, I just want to get all that straight. Go ahead.
I noticed in the interview on this latest PSI that it states interview with defendant during a jail visit on January 20th. And I believe that Ms. Simon was at that jail interview.
There was another officer in my place that day.
Okay. It says that Mr. Shiloh made statements such as, I learned I need to be more careful and ensure my phone is clear. That is not, I've learned that I need to stay away from websites such as, I hesitate to even state them on the record, Your Honor, in the report by Julia Ayala. This is 5 years later, from May 5th of 2021. We're almost to 5 years later, and we're here for the same thing. He's been to prison. He's had an opportunity to follow your orders under the adjustment that was made in May of 2025 and the following orders of June of 2025. And it just keeps going. I note that under recommendations that Mr. Shiloh remains a risk to the community, according to this PSI, and the state would agree. The state does not believe that any GPS monitoring device would prevent what continues 5 years later. Our children are the ones who are at risk because his victims were not adult women, but a 15-year-old child. And it looks as though that's the same kind of pornography that was found on the phone. So it's the state's position that his probation should be revoked. And if this is the correct time, it's my first sentencing hearing in your court. The state would ask that these sentences be stacked under Penal Code 3.032A, because these are these adjudications are under 22.011, sexual assault of a child. It doesn't matter if the victim is the same. It doesn't matter if it's in the same criminal episode, that the code allows us to stack these sentences. And I would further state that even though the agreed punishment recommendation was for 10 years deferred and that the sentences would run concurrently, that agreement was based on the fact that, or the idea that he would be successful in his deferred adjudication. Certainly not that he would continue offending in a sexual manner. I think it's safe to say that even if you're looking at pornography involving a child, you are offending against children in that way. And so whatever this court determines is a proper sentence, the state asks that the sentence in these cases be stacked.
My issue with them being stacked is that original plea agreement was for concurrent sentences. And so I think based on that, legally, I'm not real sure that is something that would be available to the court, because it was negotiated at that time. It didn't say concurrent unless certain violations or things like that. But I certainly agree with many of the other issues. Anything else, Mr. Lewis?
Judge, not from me, whatever Mr. Shiloh does want to address the board before.
All right, go ahead, sir.
How are you, Ms. Willis, Your Honorable West? I just want to say that I take my probation very seriously, and I also do take responsibility for, what was discovered in my phone. I have taken great steps to progress and the things I've done since I've been released. I've always been on time, always complied with what was asked of me in probation. I've never missed my sex offender class. I've paid my fees. I've completed my community service. Anything that's been asked of me, I've gone above and beyond to do that.
Not anything,
That's fair. Yes, ma'am.
not anything.
Yes,
The most important thing you haven't done.
Yes, ma'am.
The most important thing.
And-
And I think, well, let me just stop you. I'm going to do this. That you have not taken advantage of what treatment you should have gotten to this point, and puts, in my opinion, every young person and girl um in our community at risk. You're 40 something years old at this time. You were 37 when you had sex with a 15-year-old and did all of this. It's not like this is you're 17 and they're 14 kind of thing. This is a true, in my opinion, predator on young girls. And so for that reason, at this time, I'm going to find that you entered your pleas of true in each of your cases freely and voluntarily. And cause number 19-32403, find sufficient evidence to find you guilty, and at this time find you guilty of sexual assault of a child. Sentence you to a term of 20 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 19-32404, also find at this time sufficient evidence to find you guilty and find you guilty of sexual assault of a child. Sentence you to a term of 20 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These cases will run concurrently. If I could stack them, I think I probably would, but I don't think legally that is something that is at my disposal. So they will run concurrently. I am going to hand you the trial court certification that shows this was not an agreement. You'll get a copy of that. You do have some rights to appeal. You can talk to Mr. Lewis about that. I need both of you to sign that, and then I'll give you your copy. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Sir,
Yes, ma'am.
possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lewis. You can go back with the bailiff. Thank you. That's for him and you.
And Your Honor, next time I make the request, I will know whether or not it's within your
Thank
authority
you so
to
much.
do it.
I appreciate that.